Hello, this is Sky Moore. This segment is on bankruptcy. And I'm not worried about your bankruptcy, but you should be worried about the bankruptcy of the other party to a transaction. And you've got to protect yourself up front. And you just need to be aware of a few rules in bankruptcy that might thwart what you expect to happen. Here's the first thing that happens in a bankruptcy: the automatic stay, which is the moment the other side declares bankruptcy, you are stopped from taking any further action to enforce your contract, to foreclose on their assets, to do anything. That's called the automatic stay. You're gonna have to wait through the bankruptcy until you can do whatever it is that you want to do. Second thing that happens is that your contract will be put in one of two piles: the executory contract pile or the non-executory contract pile. And the question of which pile it goes into is in a bit of disarray in the courts. There's a split of how they treat it. But in general, if the debtor has any remaining contractual obligations to you, your contract will be treated as an executory contract, and then the debtor is given two choices. They have the right to either reject your contract or to assume it. What does that mean? Well, that means if they reject it, that means they have the right to breach your contract with impunity, and that means that you end up with a claim for damages. Good luck collecting it. The courts are often interpreting rejection as termination of your contract. Technically, that's not accurate, but that's how the courts are treating it. The other alternative on an executory contract is they might assume the contract, which means that they agree to perform it, and in which case, if they do that, they have to show the court that they have the ability to perform it, and more importantly, they can only assume the contract if it is assignable to a third party outside of bankruptcy. Most licenses are not assignable. It's an interesting glitch in the law. Even if they've paid for it in advance, they may find that they can't assume it. If your contract is in the other pile, that is the non-executory contract pile, then generally the debtor doesn't have anything left to do. You've already been paid, and the contract just stays in force, and there's not much that you can do. The next issue that comes up is voidable preferences. And voidable preferences gives the bankrupt company the right to receive back any transfers that they have made, and transfers includes payment of cash or transfer of property or the grant of a security interest. If it was made within 90 days prior to the bankruptcy, and it was made while the bankrupt company was insolvent, and it was made on account of a pre-existing debt, and the recipient of the transfer was better off as a result of that payment or transfer than they would have been in the bankruptcy. So, for example, they paid their law firm on account of an outstanding bill. Well, they might be able to get that back because it was a transfer within 90 days while they were insolvent on account of a prior debt, and the law firm's better off. Or if it was a distributor that made a payment on a minimum guarantee in exchange for a film that they had contracted for earlier, they may be able to get that payment back. So you've got to look out for this issue and be aware that if you've got a payment and the company's shaky and they go under within 90 days, you may be giving it back, which is not a happy day. Next big issue that comes up in bankruptcy is fraudulent conveyance. And this is even broader than voidable preference. The bankrupt company has the right to get back any transfers that they make within 4 years prior to the bankruptcy if they made the transfer either for less than full consideration while they were insolvent, or they made the transfer with the intent to hinder and delay creditors. So, classic example, a company's in financial trouble and is forced to do a sale of its film library at fire prices, and it sells it way below market value. And they then go bankrupt. They may be able to rescind that sale as a fraudulent conveyance because it was a transfer within 4 years while they were insolvent, below market value. Right? They may be able to get it back. Another example is when a person or a company transfers assets to their mother, friend, affiliate to try to hide them from creditors. And again, the bankrupt may have to pull back that transfer if it occurs within 4 years. the creditors can effectively force it to come back in order to give them a source of recoupment. Let's do a simple example, which is not pullback. Let's say on the day before bankruptcy, a bankrupt company sells its film library for $100 million, and it's worth $100 million. Question, can the creditors get back that film library? Answer, no. It's not a voidable preference because it wasn't on account of a prior debt, and it's not a fraudulent conveyance because it was a transfer for full consideration, and it wasn't with the intent to hinder or delay creditors because they got cash. So it's, again, it just highlights the importance of looking at the facts, but those are the key things that you need to be aware of in bankruptcy. If you're aware of those issues, you can often contract for them in advance, get a security interest to protect yourself, keep ownership of the rights until the preference period is passed, or do something to protect yourself, okay? And that will keep you in good stead. This is Sky Moore tuning out for this segment. Hope you join me for the next one. Thank you.